Welcome to another episode of Let's Start Justice with the JFJ team. My name is Michael Jackson, Executive Director of JFJ.
And I'm Jade Williams, Policy and Advocacy Specialist at JFJ.
Now, we're already in the second month of the year, and while some of you will be celebrating Valentine's Day next week, I want you to keep love in mind for some of the more vulnerable in our society. And on some of the issues that we focus on, for example, children who are going to be subjected to mandatory minimums and so on if these laws are passed. So love in mind, but love for everybody, right? So I hope we will continue with that theme as we celebrate love, but love for all. All right?
Yes.
Today we're going to be discussing a topic that we started last week, but given the developments in the country, we felt it important just to break things down a little bit regarding the Office of the Political Ombudsman and the proposal coming from the Honorable Delroy, Minister of Justice, and whether or not to subsume that office into the Electoral Commission of Jamaica. So we will be discussing that. Yeah?
Yes, we will.
And you're doing well, Jade?
I'm doing all right.
All right,
I'm
great.
a bit jarred by the fact that we're in February, but
Oh, the year moving quickly?
yes.
Okay. You only worry about these things when you're worried about age and so on. Right?
I'm worried about work.
Oh, Lordy. All right. The week that was, last week we mourned two significant contributors to Jamaican society. First, we remember veteran broadcaster Alan Magnus. For those of you who grew up hearing Alan and Doreen in the morning, good morning, that kind of vibrant, we can't replicate that voice, but
Yeah.
that kind of vibrant, and he was a singer as well. So
Yes.
I heard on a radio program a couple of his songs being broadcasted just so we could reminisce a little bit on Alan. So we certainly mourn that loss that Jamaica were collectively going through. And last week we also lost Justice Dennis Morrison, former president of the Court of Appeal, and we saw a lot of the pouring out on social media, press release from Jamaica Bar Association, just indicating how important he was as a teacher, as an instructor of the letter of the law, but also the spirit of the law as we apply human rights concept and principles as we understand the law and practice it in Jamaica. So for those of you who were taught by Justice Morrison, based on what we have been hearing, he seemed to have been such a great man that obviously we also celebrate what he has contributed.
Absolutely. And I was one of his alumni, so
Great.
it was a shocking, but we celebrate, as you said.
Yeah. Now, another issue coming out of last week, the Jamaica Gleaner titled it a legal firestorm, they say, when the Director of Public Prosecution, Paula Llewellyn, decided to withdraw a matter from before the court before a sentence was imposed. And the particular matter had to do with a young man pleading guilty to rape and grievous sexual assault. And the judge, which is quite in keeping with the procedures of the court, had given an indication that upon pleading guilty, a non-custodial sentence would be so imposed. And Jay, just for the listeners, just explain what a non-custodial sentence is and the implications of it.
Well, essentially it means that the person will not be incarcerated in a correctional institution. They may still have other obligations that the government would monitor, but they would not be forced to be imprisoned as would normally.
And in most instances, if you commit another crime, then
Yes, that you would end up having to serve that non-custodial sentence in custody.
So just to put in context, and we're not privy to a social inquiry report, but apparently neither was the court. This young man committed the act of rape and grievous sexual assault when he was 16 against a 17-year-old girl. That's what I recall from the case. However, rape and grievous sexual assault carry a maximum term of life imprisonment.
Yes.
So just to put in context for us, there were particular areas of the DPP's argument that were meritorious.
Yes.
They were not without merit.
Yes,
The
for
concerns were quite valid. The DPP argued that given the seriousness of this particular act, then in her estimation, imposing a non-custodial sentence would be unjust.
Yes.
And she used the line that the pendulum of justice must swing to the victim, not just the accused. One can agree.
Yes.
She also indicated, her words no, that the court proceeding was irregular. So in other words, apparently the defense asked for there to be a discussion about the sentencing, and the judge entered into some conversation without a court reporter being present, which means that the conversation would not be documented where a court transcript could so be provided. The DPP also raised the concern that imposing a non-custodial sentence with an absence of a social inquiry report to indicate these are the particular vulnerabilities and so on of this offender would be unjust. Again, one can't argue with these concerns being put forward. However, we share the arguments and the concerns coming from the Southern Bar Association and the Advocates Association, and I think Bert Samuels as well, saying that what the DPP should have done was to allow the sentence to be imposed, the matter concluded, and then the DPP should exercise her right to appeal.
Yes.
Because to basically stop a proceeding because you're getting an indication that this is a sentence that you will not like, some argue is an abuse of the discretion that the DPP has. And Bert Samuel says it's setting a bad precedent.
I have to agree with my learned friend. In consideration of even some of the conversations that we would have had about sentencing and the need to increase or to adjust or to review the way that we impose sentences, one of the challenges that we've had is evidence that this review is needed. A matter like this, where there's a indication that there is a disproportionate, in the light sense of the word, sentence being given, is good evidence to show that there is a need to review the way in which sentences are applied. However, not allowing the sentence to be given puts the DPP in the position that Mr. Samuels would have said, where she has used her discretion in such a way that we cannot be certain was contemplated when that discretion would have been given.
There must be certainty in the court proceedings. And I agree. The conversation for me, and I don't want the listeners to think that we're suggesting that the judicial discretion, as was about to be displayed in this particular matter, ought to be undermined. And we're not suggesting that the judge perhaps didn't consider certain factors. What we are saying is that if there are procedures in law where the DPP has the power to write or the right of appeal, and by the way, when this was granted in 2010, that was another legal firestorm that existed. But the question is this an abuse of power where you can have the DPP withdraw any matter if they're not happy with what is happening, and then basically as a reporter asks the DPP, was this a matter of you going judge shopping? So there are several things where people looking on and say, okay, the court system is not as certain. There is not the guarantee of certainty for either the victims or the accused, and that is something I think ought to be contemplated. So I agree the DPP should have had the matter being concluded and then exercise the right to appeal. All right?
Yes. So that is it?
Yes, over to you.
All right, so we'll just quickly do our trivia question before we go into our substantive topic. Our trivia question was, what year was the Office of the Political Ombudsman established? And we'll also do a Did You Know from the Political Ombudsman Act. And that Did You Know speaks to Section 6 and 7 of the legislation, where it says that a person is able to...
So we need to get a Did You Know on the screen instead of the trivia?
Yes, okay. That a person is qualified to be appointed in the office of the Ombudsman if he is not a member of the Senate or House of Representatives, is not an undischarged bankrupt person. So that means you have filed for bankruptcy and it is not discharged as yet, or has at any time been convicted of any offense involving dishonesty or moral turpitude. Now, the Ombudsman would have to vacate the office should any of those circumstances arise during their tenure. And when that vacancy arises, then the Ombudsman role can be filled by the Governor General after consultation with the Prime Minister and the leader of the opposition, and they may designate someone to act in that place until a further appointment is made permanent. So that's Section 6 and 7 of our Political Ombudsman Interim Act.
All right, so we won't disclose the year of the act because I think that's the question that you asked.
Yes, it is.
But just to indicate that when the act was written, it's an interim act and it awaits the constitutional entrenchment.
Yes, which was Section 3.
Yes. So just to also say to the listeners, the importance of the political ombudsman is that that body exists to ensure that the political code of conduct is adhered to by our political leaders. But when the office became vacant in November 2022 following the departure of Donna Parchment Brown, we got an indication from the government. First indication was that the office would completely be disbanded. Yes. And then by January the following year, we heard that the office may possibly be subsumed into the Electoral Commission of Jamaica. But that made no parliamentary or the legislative agenda for the year at all. It was just an announcement from the Minister of Justice.
Well, on January 30th of this year, 2024, the Minister of Justice, Honorable Delroy would have tabled the Political Ombudsman Amendment Act 2024. And this is the legislation that is intended to see the office be subsumed into the office of the Electoral Commission. Now, the bill was intended, when it was tabled, to be taken through all of its stages. However, there was some resistance coming from the leader of the opposition, who cited the fact that the bill had just been seen by them for the first time that afternoon and challenged some of the proposals that were in the bill as well.
The Electoral Commission has achieved a level of stature in the society, even internationally, because it is perceived as being independent and out of the fray. And it takes its decisions not by favoring any political party, but in the interest of fairness and efficiency of the electoral system. And that is a very valuable reputation to have developed. That stature should not be diluted, or we shouldn't play games with it. By investing these responsibilities in the ECJ, they are now going to have to adjudicate like a quasi-judicial body on matters that will be intensely in dispute between partisans in the political process. And that is now changing the character of the ECJ by giving them functions which are completely inconsistent with the detached, independent, and objective aura that they have enjoyed for so long.
Now, this spurred a strong response from Minister Chuck.
Why would we discuss a matter when we have agreed in this parliament? We agreed that it should be subsumed. And all that took place is that it never, and as I pointed out, it never happened in your time. When we took over, we decided not to interfere because the political ombudsman was in place. So we waited until the political ombudsman term had expired. And all along, we have said it repeatedly that it will happen. And no one has ever objected. All of a sudden, Mr. Speaker, all of a sudden, at the 11th moment, there is objecting. Why are you objecting at the 11th moment?
No, that was Minister Delroy Chuck. Just to indicate that last week's parliamentary sitting saw the best and worst of Parliament, as we've been saying publicly. You saw a bill being pushed through in a matter of hours. They wanted to conclude the tabling of the bill and having it been taken. Yes. So that is the worst of Parliament, because you should have your legislators being able to review things and having discussions on it, given the implications of it. But the best of Parliament also came to the fore, where we saw backbencher, former Minister of Industry and Commerce, I believe, Carl Samuda, yes, saying to Minister Chuck and the parliamentarians, do not tinker with the Electoral Commission of Jamaica. And certainly JFJ, NIA, CAFE and others believe that the office ought not to be subsumed with the ECJ, and JFJ has called for an immediate reinstatement of a political ombudsman, and then you can table the discussion to be had at a later date. We're going to be joined by Dr. Lloyd Barnett, constitutional expert who also sits on the Constitutional Reform Committee, Reverend Newton Dixon, who is the General Secretary of the Jamaica Council of Churches, and Daniel Archer, Attorney at Law and Principal Director of National Integrity Action. So we take a break and we continue. Hi, welcome back to Let's Start Justice. We are discussing the issue of the Office of the Political Ombudsman. Just for the purposes of our listeners, the bill is expected to be retabled in Parliament today at 2 o'clock, and we are not yet sure the government will be utilizing its parliamentary majority and just continuing to push it through. And you know, the government controls 48 seats with an independent also supporting the political party. So we expect the bill to go through today, unless Minister Chuck has been guided by the public discourse rather that has taken place. So we're joined by Daniel Archer, Principal Director of NIA, and Reverend Dixon of the JCC, Jamaica Council of Churches. Good afternoon to you both.
Afternoon, Reverend. Good afternoon, hosts, and certainly good afternoon to your listeners.
Daniel, you sound a little bit tired.
You know, I will be honest with you. I actually thought our conversation was tomorrow because I'm actually coming out of court just now. When your assistant called, I thought, But we're ready to go ahead. It's the people's business, so we must always be ready in spite of how I may feel. It's more important that we attend to those issues. And
absolutely. We push aside lethargy.
I'm me to tell you.
So we'll start with you, Daniel. What is your position from NIA's standpoint, your immediate reaction to the proposal?
You use a nice word, which shows how nice you are and how not so nice Daniel is. You use the word pushing through. My word is ram it through Parliament. Because you run it through Parliament, and we have developed a kind of haste, which is unbecoming of a democratic sitting. Whether or not there have been conversations behind closed doors or conversations in the hallways, the point is that you have these discussions in Parliament so the people may know. I don't know which parliamentarian said what, where, and when with this in the hallways, if it's over dinner downstairs, or if it is that they're having a conversation on the way to the car park. People know what is being said about the matter and how their representatives feel when they hear them in Parliament. So I have a challenge first, hearing Mr. And it was a knee-jerk reaction, like, what do you mean we agreed and there are no objections and we're going with this now? It kind of rubbed me the wrong way because it meant the people didn't hear and the people don't know why they're agreeing. And secondly, whilst I was in court, I actually had to, I know this is radio, but I had to take out my earpiece to see a video that was sent to me. And it was sent to me with a heading, "This is what has happened to a councillor by another person bearing party colours for wearing the wrong party colour."
You're talking the incident in St. Thomas?
Listen, I haven't been able to verify it.
So it's in court. Yes, the incident actually took place. Apparently, the political representative in the video is Mr. Dean Jones, and his attorney has since spoken that he was defending himself. So
hold on, pause there. Has something really happened?
Yes, it did today.
Okay, so you know what that tells us? In a matter like this, where you are going to be quote-unquote defending yourself or assaulted because of the colors you wear, it means there is an opportunity and a need to have the political ombudsman. So let me repeat. Because we still have that little isms in us where we look upon people and treat people and say things that are not becoming as politicians. And because as supporters of political parties, we tend to be incited out of whether it's euphoria or reverence or allegiance we tend to do things that do not reflect modesty. Modesty is such a nice word. It doesn't reflect the elements that would favor this kind of. Let me be true to myself. We have the aggressive elements, the things that identify political parties, and we try to force it down everybody's throat. Once again, ram through the idea. If you don't believe what I believe, this must happen to you.
Right. Thanks,
The
Daniel.
fact that we have not had the political ombudsman to mediate, to resolve these issues, to act as a referee, leaves us wide open for such incidents to continue.
Yeah.
This is not the job for the ECJ.
Right. Let's bring in, thanks, Daniel. Let's bring in Rev, and we are now joined by Dr. Lloyd Barnett, but we'll take Rev's view first before we get to Dr. Barnett. Rev, what is the position of the Council of Churches?
Good afternoon, Michael and team.
Jade is here with me.
Yes.
Right. Good afternoon, my dear. And as well as Dr. Barnett and my very good friend Daniel. I've never disagreed with Daniel, and I don't intend to start doing so now. And so I want to just simply say I concur with her, with the additional note that given our history, despite the progress we have made in matters relating to elections and campaigns, and given our temperament, and
That's
also the fact that we are always in a situation where political contests are very highly charged. We do not want to take the risk of not having an arbiter in place that can assist us to navigate what will almost inevitably be a very difficult political season. I'm not calling down gloom and doom. I'm just simply saying we don't want to take the risk because political contests usually lead to some sort of disagreement or discontent. I think it is critically important for us to have in place a political ombudsman who will assist us in navigating those differences which will occur and those issues which will arise, and help us to, in a peaceful and amicable way, as has always happened, whether it was Bishop Blair or Mrs. Parchment, as has always happened, we have had a very good history with our political ombudspersons, because they've always been able to bring parties to the table to either make recommendations to the political parties or to work out solutions between the contending individuals. It beats me that we are not going into this election cycle with a political ombudsman.
Well, it depends on the outcome of Parliament today, Rev.
You know,
all right. and let us be hopeful that reason and, as you said earlier, the conversations that have been taking place, the views that have been expressed, and in some respects the objections that have been raised, and the call that has been made for an ombudsman to be in place, we hope the government will hear the people, will hear the conversation, and will act accordingly.
Thank you, Rev. We have about 2 minutes before the break, but I wanted to ask you, Dr. Barnett, on your perspective with the amendment that was tabled last week.
I agree with all that has been said of the need to have someone in that office at the time of political campaigning when tensions rise. But it is not appropriate or wise to vest that power in the Electoral Commission, which is involved in the administration of the elections themselves. This is a completely different field and needs a particular person to be assigned for this task. As mentioned earlier, the tensions have already manifested itself in violence, so that it confirms the need for such an office. The Electoral Commission is not set up for that purpose. And secondly, persons who anticipate or see something which is unethical, challenging, and wish to make a report should be able to do so in confidence, knowing that no political person knows of the person who has made the report or can identify the person who has made the report. The Act which establishes the Political Ombudsman provides for that degree of confidentiality so that you would not have confidence reporting to a body which consists of politicians.
Dr. Barnett, please hold that thought. And on the other side of the break, I would love for you to pick up on the conversation about the structure of the ECJ, because based on what we read, it seems as if the government is just pulling a particular section, I think clause 12, section 12 of the Office of the Political Ombudsman Act, and just pushing it into the ECJ and thinking that that would suffice. But you noted a critical part in terms of the matter of confidentiality, given that you do have political party representative being a part of the ECJ. So I would love for you to just explain the implications of it based on the purpose of the political ombudsman vis-a-vis what the ECJ is expected to carry out.
Welcome back to Let's Talk Justice. We've been discussing the Office of the Political Ombudsman, and we are joined by Reverend Newton Dixon, Daniel Archer, and Dr. Lloyd Barnett. Before the break, Dr. Barnett was going to give us an understanding of the structure of the ECJ and some of the concerns around confidentiality and making a report to the Office of the Political Ombudsman. Dr. Barnett?
Yes, the ECJ comprises both independent members and representatives of the two major political parties. And therefore, it is not a completely non-political organization. And therefore, if the obligation to maintain confidentiality, which the political ombudsman has to subscribe to, is compromised by the fact that complaints made confidentially, in confidence, has to be communicated to a body which comprises political figures, then the basis on which those arrangements have been made would be defeated.
Yes.
So that I think it is completely inappropriate to transfer the functions of the political ombudsman to the Electoral Commission.
Thank you so much, Dr. Barnett. Daniel, just to pick up with you, one of the things that leader of the opposition, Mark Golding, raised during his objection in Parliament was the process of adjudicating matters, whether or not the bill, as was tabled by Minister Chuck, fell short in explaining those procedures, whether all 9 commissioners will be a part of that panel, for example, to hear the complaints and follow them through. I'm not sure if you've managed to take a look at the bill to give an assessment of whether or not what has been tabled really fell short in reality and practical procedures.
I think the comments made by King's Counsel, Lloyd Barnett, make sense.
Yes.
You have to look at the mischief. So in law, we have this thing that says, what's the mischief that the legislation is supposed to cure? So legislation comes about for the purpose of fixing something. And one can look at what was said about the ECJ and why they were comprised. What's the purpose, which is very different from the purpose of the political ombudsman, who is supposed to be seen as not political at all. So what you're now asking is for political actors who are either aligned to a particular party or not, the same office, the same building. So whether you want to say, oh, they won't have anything to do with it, they're still political actors. You want the security of independence, which is what the Office of the Political Ombudsman brought. There's another factor, though, that I found very interesting, and maybe I missed it, so you can tell me if I did. But to my mind, the legislation for the political ombudsman had required that it becomes secured by the Constitution?
Yes.
Yes, at
If
section
I am
3.
correct, then what should be ramming through Parliament is the protection, the constitutional protection, which was foreshadowed and which was what the crafters of the legislation wanted.
And that bill was actually tabled in 2011.
I was heading there.
Yes.
So we had this intention and this recognition that the office of the political ombudsman would cure the mischief. At no time at all was there any indication, whether by agreement in the hallways that we didn't hear about, or comments in Parliament that we would have heard, that this was wrong or manifestly incorrect. As far as the public has been led to believe, the office of the political ombudsman was so important that the crafters or drafters of the legislation intended that it be protected by the Constitution. That hasn't been done. What we seek to do now is to subsume that responsibility with the ECJ, whose purposes and objectives were never conceived as being referees when there's a dispute between political parties in an election.
Mm-hmm.
To my mind, you don't have to look at what was being said in this legislation as it's being rammed through the Parliament. What we must look at is, on the face of it, has it changed the whole arguments that they were putting before us before? And it has. So we must now ask ourselves, why? Is there a motive? And is there even greater motive when you don't want us to discuss it? And this is something that I think our senses, or spider senses as they would say, should raise. Why is there this desire to utilize the majority at all costs without giving an opportunity for even the public to weigh in on these matters? We must be mindful that we as a people, they represent us. Legislation or laws that are passed must be reflective of the people and the people's will. That's the concern that I'm having listening to the legislation and looking at the legislation as a whole as it's proposed. I have a concern that it does not reflect nor aim to cure the mischief that the original legislation for the political ombudsman sought. And I desire an explanation as to why we would not seek to secure and protect the office and appoint somebody independent as has always been done. And why there's a race now to have the ECJ, as my colleague has said, who has had an impeccable reputation, to now be one that is solid by partisan natures and partisan arguments.
Well, how would you respond to Minister Chuck's statement in Parliament last week that the commissioners themselves are abreast of the provisions and are prepared to take on the...
Torif Nixon.
Okay, so we are abreast of the provisions in the Road Traffic Act. Are we all prepared to enforce it? Can we all enforce it? You and me read the Road Traffic Act. We are abreast with it. Can we all enforce it? Was the act intended for all of us who understand it to enforce it? No. The act was intended for a special set of people to enforce it. And the act as it is was not intended for the ECJ to enforce it. It was intended for an independent individual. In fact, let me go further. We have had this conversation about the political ombudsman being a paper tiger. For the benefit of your listeners, really somebody who sounds very loud but they have no power nor no strength. And what
to jump in here, I'm not sure if the act was ever revised, but from what I recall, the maximum fine that could be imposed is Jamaican $50,000. I'm not sure if that fine was ever increased.
You see where you're going with the conversation now, right? There was no true strength in the legislation. And if we really wanted to ensure that we did not revisit the past, what we would be doing is following through on securing the legislation in the Constitution and giving her teeth or him teeth, giving the office powers to ensure that the behavior, the caste behavior of our politicians, their refusal to adhere to a particular code of conduct that they have signed that govern how they behave in politics would be something that they would follow. Don't get me started now on a code of conduct, but the little one that we have that speaks to the political code of conduct, who is going to enforce that? The same people who are going to ensure that there are free and fair elections should also monitor the political behavior of aspiring politicians. Who is going to referee that? And are we going to see them as being objective when we know that they're going to be in the same and determined by persons who are either green or orange. And what about the people who are third parties, who have nobody sitting on the ECJ? Are they represented too?
You know, as you highlight some of those challenges, I know that the JCC had also identified that the office was not as powerful as we maybe would have imagined it to be. Rev, I wonder what kind of improvement you would like to see from the JCC's perspective to the powers available to that office.
Anil, left off. From as far back as last November, which I think you're alluding to, we issued a call for the government to abort the subsuming of the political ombudsman, the office of the political ombudsman in the ECJ, but instead to strengthen the legislation as it existed, one, and to appoint an ombudsman quickly. I think what we're looking at now is a situation where the church's position is that we really have to think about how we protect the, as we have all come to see, the fragile democracy that we have. Democracy comes under threat from different places, different issues, different concerns, different circumstances. And I think we need to protect what can slide down a slippery slope very, very, very quickly, which is our ability to maintain transparency and freedom and fairness and freedom from fear in our electoral process. So where the JCC is concerned, we are wanting to ensure that what we have as democratic traditions and democratic institutions and democratic values, that we ensure that those are not just that they stay in place, but that they are reinforced. And we certainly believe that putting teeth in the legislation and in the hand of the ombudsman would further that ambition and desire in a useful way.
Rev. As we close out, just last word from you, Dr. Barnett. One of the concerns that JFJ has put forward is that whether or not one believes that the office of the political ombudsman ought to be in the Constitution, the reality is that that is what the Interim Act provides for. The challenge that JFJ is having is that we have a Constitutional Reform Committee, and this is one of the main areas that were of consensus before. And we have a bill being tabled that completely disregards a consensus that was arrived at and an act that provides for that consensus to actually be done, where the political ombudsman is entrenched in the Constitution. My question to you is there a concern that we have bills being pushed through Parliament that almost circumvent the constitutional reform process?
It certainly is a matter of concern and disappointment that has happened and is happening. And certainly, if we are going to do and be engaged in a genuine process of comprehensive constitutional reform, then any changes of that nature should be dealt with in a comprehensive way and dealt with by that committee and that process, rather than in some piecemeal, sudden knee-jerk action. I don't necessarily agree that any additional power should be conferred on the political ombudsman, because you run into serious constitutional problems if you start giving punitive powers to non-judicial institutions. So that I'm not in favor of extending the powers. I'm in favor of protecting the office from, this sort of manipulation and transferring the functions to a body which was not set up for this particular type of activity.
Yes. Thank you so much, Dr. Barnett. Thank you so much, Ms. Archer, and thank you so much, Rev Dixon. We appreciate your views, as usual. That was the team of experts, if you will, discussing the Office of the Political Ombudsman.
Yes.
And I think we all collectively... Yes, go ahead.
I was adding a disclaimer to the title expert, not me.
I'm giving it to you just the same, Rev. But thank you so much. We appreciate you. We take the break and then we return. Welcome back to Let's Start Justice. You know, somebody just WhatsApped me, Jade, and to say that we're speaking in airy fairy land here at JFJ along with our other experts, I'm calling them still. Because from their perspective, the country has to save money. And why do you have a seasonal body? And if you would just allow me just to put some historical perspective on these things. When we gained our independence in 1962, we had no structure, no institution. And we have a two-party political system in this country, where, as you can see, the opposition, you know, they don't have the power because they're not represented in the executive body that controls the ministries and the resources of the country. Most legislation can be passed with simple majority vote, save and except for the ones that are entrenched or specially entrenched, yeah? So the only thing you can do is to walk out of parliament. And again, based on the parliamentary system that we have, you object, you walk out, and the business of parliament continues. So former Prime Minister Bruce Golding made an infamous statement. I remember studying politics at UN. He said, when you're in opposition, you control nothing. So because there is that thrust for control, you do anything to get power, so to speak. Political violence, ballot stuffing, people voting even though you're dead and gone long time, and so on. So in 1978, you had this body that was established called the Ombudsman that existed to deal with maladministration, wastage of resources, corruption. You also had an electoral advisory committee. These bodies have evolved, wherein the Ombudsman, as it was called in 1978, you have seen an emergence of what was the Contractor General to now the Integrity Commission.
Yes.
As well as other bodies dealing with ensuring that the business of the people can withstand scrutiny and there is integrity. The Electoral Advisory Committee led way to 2006, the Electoral Commission of Jamaica. Because of our political history, the Political Ombudsman was established, and I'm trying not to use the date as not to give away anything. So that was one perspective. You have to be looking at history and the past that we never want to return.
Absolutely.
Right? Now, we went through a constitutional reform process in the 1990s. One of the recommendations coming out of that 1995 report was that you would have, my apologies, a political ombudsman body that would be secured in the Constitution, because you don't want to be making announcements and imposing fines, and there's the threat of being dismantled with ease.
Yes.
There's the threat to you where you're fearful and can't exercise your duties. So from that perspective, the political ombudsman is important. The political ombudsman ensures that the political code of conduct, that body will ensure that the political leaders and aspiring political leaders respect that code of conduct, wherein you don't threaten anybody, you don't participate in vote buying. Many things are there.
Yes.
It needs strengthening for sure, as Daniel Archer mentioned earlier. But it is the framework to ensure that there is integrity of our political leaders. Now let's look at the video today that emerged with the JLP representative and apparently some supporters from the People's National Party. We made no pronouncement because we weren't there. and the police is apparently investigating the drawing of the firearm and so on. But already on social media, you see people saying, left my party alone. The man was defending himself. Those who support the PNP saying, you see, this is what the government is bringing back into the political arena. Now, if you had the ombudsman role being subsumed into the ECJ, and the ECJ made any pronouncement whatsoever to say that you are wrong or you are wrong, let's not kid ourselves that you won't have that kind of partisan sound bites that we see happening on social media, and the ECJ that has emerged from a single electoral officer to an electoral advisory committee to now having a body that awaits its constitutional protection, now being caught up in political cascas. And then the ECJ that exists, Jade and listeners, to ensure that we don't go back to the stage of gerrymandering. That is when you change up the constitution, the constituency boundaries to your liking so you can secure your vote and your safe seats and so on. Mm-hmm. Can you imagine when the ECJ acts, what people are going to be saying? A long time they're in politics. They're politically biased. So the ECJ's role has now been undermined. So you have to be asking yourself, it may cost a little bit of money to keep the political ombudsman. But when we're dealing with a democracy, it's not just financial cost that you weigh.
Yes.
Because some things are far too important for us to be asking the question, them only seasonal.
And you know, even to that comment, I don't agree with that, because we are not a country that limits our campaigning as is in other jurisdictions. We can be having political party related discussions all the time, all year. And we have seen in recent times, in the time that the office has been vacant, exchanges that were unrelated to electoral pursuit that would have needed an intervention from the political ombudsman. And therefore, we cannot think that it is so seasonal that we would only need this office during electoral period.
But Jada, take it a step further. Just last night, and I love my students, but this class is excellent this much. But last night I had 50 students on. And I said, how many of you ever vote? I said 6. At the Zoom hand raised. So of course, Mikkel, being Mikkel, I said, me sure no under 18 years old. So how many of you ever voted enumerated? I see 3 more hands raised. 9 of 50. And the conversation, their justification, miss, I have no interest. Because this is how I perceive the political leaders to be. Or miss, I just don't know enough. So the political ombudsman could be that person who does adult civic and education in this country to let people know what the structure of the government is, the importance of civic participation, and so on. Interestingly, Donna Parchment Brown, before she demitted office, she actually put forward a book. I don't even know the status of that book.
Yes.
She did a book, on this very topic. So that education is lacking. So when we talk about financial costs, let's weigh the cost. Is 37% of the population voted the last general election. And don't even get me started on the local government.
Yes.
Right? This is the strength of our democracy. And we need leaders with integrity who understand their own roles in parliament. Too much backbenchers, not the benches. Yes. Not reading the bills. So it's a full gamut of responsibility on both the citizens and the political leader standpoint. And these things are far important for us just to be having a conversation about economic cost. Yeah, but
absolutely,
that's my ranting for the day.
And I appreciate it. We should start calling this this last 10 minutes of the show or 15 minutes of the show Mikkel's rant.
No, we won't do that.
Yes, your producer is agreeing. Our engineer is in agreement. Thank you, Kevin. All right, so we are at the end of the show, and I can finally give the response for our trivia question. Mikkel has been keeping herself
In check.
quiet. But yes, so the question was, when was the Office of the Political Ombudsman established? And the answer is 2002, and that is the same year that the act would have been tabled and passed.
And it's now 2024, and what happened to the constitutional entrenchment?
Yes, we still have
Yes.
not seen that
And
constitutional
ECJ
entrenchment.
2006, also an interim act. And
Yes.
just to say to the listeners, if the government can demolish the Office of the Political Ombudsman by simple majority vote, just to let you know, the Electoral Commission also has no constitutional protection. So there's nothing stopping any government to go in Parliament next week and say, be done with it.
True. And that's why we need this protection. But we will continue our discussion. I hope you all will be watching Parliament now to see how that develops. Thank you so much for joining us. I'm Jade Williams.
And I'm Michael Jackson. Have a good day.